Okay, wonderful. Thank you for making the time to join. Much appreciated. It's much nicer to at least have some faces in front of me than just having to record the class. Let me share my screen. Okay, that is the document that I've been using to make my notes on as we go along. Just give me a thumbs up quickly if you can actually see that. Have I successfully shared my screen? Okay. Okay, so what we're doing is we've started looking at the law of partnerships. Found out that a partnership is not an entity. We tend to think of a partnership as being a business, but in fact, a partnership is not a business. It's not an entity. It is a contractual relationship between people. And sometimes people can even enter into a partnership without realizing that they are in a partnership. Keelan and Silvana decide they want to earn some extra weekend for the money for the weekend. They each contribute $100, buy some bread at Checkers, make sandwiches, sell sandwiches on the night campus. Whatever profit they make, they divide between themselves to fund whatever they have in mind for the weekend. That is a partnership. They just decided, let's make some money. They didn't decide, let's enter into a partnership. They didn't go and see a lawyer to craft a 10-page document for them. But it is still a partnership. Now, the essential elements, as we learned for this contract, to be classified as a partnership. And as we go along, you'll learn that it is important to know whether we can classify a specific contract as a partnership or not. Because as with purchase and sale, lease, etc., there are certain natural legal consequences that follow because it is a partnership. So, in order to determine whether these consequences are applicable to an agreement between the relevant contractual parties, we have to know whether it's a partnership or not. One of these we've already looked at, we'll get back to that. It's the concept of joint and several liability. If you were in a partnership and the partnership dissolves, comes to an end, but it is still owing money, then the partners can be held jointly and severally liable for those outstanding debts. A creditor can choose which of the previous partners to hold liable and can collect the full outstanding debt from them. Obviously, an important consequence there. So what we've done so far is we looked at the requirements. Our requirements are each party must contribute. Business must be for the joint benefit of the partners, and the object must be to make and share a profit. We looked at those various requirements in a little bit more detail. However, it can be that there can be an agreement without, or which might seem like a partnership, but isn't actually a partnership. It might seem as if the elements are present, but they aren't. Let me give a quick example here. Keelan and Marilyn agree So what do we have here? Keelan and Marilyn agree that Keelan will conduct a farming business on the farm on the property owned by Marilyn. They agree that Keelan will pay $10,000 to Marilyn and the rest will be shared equally between them. Now, looking at that, do you think that is a partnership or not? If you're in a place listening to the lecture where you can't switch your microphone on, just give me a thumbs up. Do you think that's a partnership?
That cannot be a partnership, because partnership is if they are working together.
They don't know. Not. Thank you for answering, George, but not necessarily. They don't always have to work together. That is not a requirement of there being a joint business. A joint business is that they must both benefit out of it. Let's look at this. First point, first requirement is there must be contribution. So what are they contributing here? The farm, they're using the property. Marilyn is contributing her farm. She's making it available. And Keelan is doing the work. The labor is her contribution. So there's contribution. They are both going to benefit. They're both going to benefit, and there is profit sharing. So, George, looking at it like that, reconsider your answer. Do you think that could possibly be a partnership?
Yeah, when you put it that way, yeah, it's a partnership.
It could be a partnership.
Yes.
On the other hand, and I'm doing this to illustrate a point. On the other hand, maybe it's not a partnership. Maybe you were right in the beginning. Maybe it's a lease agreement. Keelan is leasing the farm, and the rental is $1,000 plus half of the rest. So, George, do you think it's perhaps a lease agreement? Maybe you were right the first time, said, but there isn't a joint business.
Yeah, it could be. It could be a lease agreement as well. Yeah.
Okay, that is exactly the point of what illustrates the section of the work, the legal concept that I'm about to discuss with you. That sometimes a particular agreement on the face of it can be a partnership, or maybe it's not a partnership. Just with that information that I typed on the screen, it can be both. So we don't know. We will need some additional information about the relationship to figure out, is this a partnership or is it a lease agreement or something else? Because on the face of it, it has the requirements for a partnership. But if you look at it from a different angle, it could potentially be. So which one is it? That brings us to the intention to establish a partnership. Usually, when parties have agreed that they want to go into a partnership, whatever, this whole issue of intention doesn't actually doesn't become relevant. Or if it's a once-off that, like I've illustrated, you're putting some money together to sell sandwiches, and then you split the profits and you're all happy, it doesn't become relevant. The issue of intention becomes relevant when there is a dispute. Let's say when our parties, Keelan and Marilyn, entered into this contract, they just agreed. They didn't go and see a lawyer or whatever. This was an agreement between them that this is how it's going to work. And for a couple of years, it works well. Keelan does the farming. She's making some money. She pays the money, first 10,000 over to Marilyn. The rest is shared. Everybody's happy. And then 5 years later, they have a fight. They have a big fallout and they want to end their relationship. And now it becomes very relevant. Was this a partnership or was this a lease agreement? Because if it was a partnership, that means the farm was a contribution. And as we learned here, the default rule is that ownership is contributed, which means, and they didn't specify, they never specified in their agreement that she will just be using the farm. They said she's going to be conducting a farming business on the farm. If this was a partnership, that farm, that was Marilyn's contribution. Marilyn's contribution was the farm. It is now the property, becomes the property of the partnership, which means they have to share in the value of the farm. Keelan will have a claim for 50% of the value of the farm. If it's a lease agreement, however, that won't happen. So can you see that with this particular illustration that I used, whether it's a partnership or a lease agreement can have very, very, very far-reaching consequences. And now our original parties are fighting with each other. Because obviously, people have a tendency to look after each other. Marilyn is saying, it's a lease agreement, it's my farm. Keelan is saying, it's a partnership. I have a claim to half the value of the farm. Can you see how far-reaching this is? Now, how would the court, so eventually they can't solve their problem, they go to court, they take the matter to court so that the court can give a solution. Because if all the requirements are present, whether the parties had the intention can be crucial. Now, at the stage where they are fighting about it, the court must decide what was their original intention. Not their intention today when they're fighting, because obviously today they're going to say, but it is a lease, and the other one's going to say, no, it was a partnership. Their partnership when they entered at the time. What their intention was at the time can be relevant to determine whether it is a partnership or not. How do the courts approach this? They use a bit of a simple formula, namely that the party who alleges a partnership only needs to that the elements of a partnership in their agreement. So in our given example, Keelan is the one that wants to prove that this was a partnership, because then the farm has become partnership property and she has a claim for half of it. She needs to prove that there was contribution. She needs to prove that there's a joint business. She needs to prove that there was profit sharing. As we saw on the face of it, that's relatively easy for her to prove. So the presence of the essential elements the court will take the presence of the essential elements as prima facie, Latin word. It means at first look, at first look, that the elements, these three elements, if they are present in the agreement, the prima facie decision at first look, it will be proof of a partnership. Which leaves our other party, Marilyn, in our given example, the party that disputes that it is a partnership. Will have to bring whatever evidence they can of a different intention, that in fact they never intended it to be a partnership. The manner they conducted the business was not in the manner of a partnership, whatever. So the one that wants to prove that it's a partnership has got the easier job in court. The other party will have to bring the necessary evidence that, in fact, no, this was a lease agreement or something else. So, George, back to you. You originally said, no, it's not a partnership because there was not a joint business. Maybe you were correct. We don't have enough information in that very simplified example to know what it was or not. If Marilyn wants to prove that it's, or was it here? Let me just get my names right. Marilyn wants to prove that it was not a joint business. She will have to bring that it's not a partnership. She will have to bring evidence that it was not a joint business. Potential evidence can perhaps be that, in fact, she was never on the farm. She never took part in the decision making. She just made the property available, but Keelan made all the decisions, etc., etc. So you originally said there's not a joint business. Maybe you were right. Maybe you were wrong. We don't know enough to conclusively answer that question. Whoever wants to prove that it is not a partnership will have to bring the necessary evidence of that. Is everybody with me here? Give me a thumbs up before I move on. Okay, then just before I walk off the concept of the intention to establish a partnership, just a reminder again that this will only become relevant if there is a dispute. Once you start arguing. Otherwise, if the parties are in agreement that this is a partnership, or a lease agreement or whatever, then it becomes a moot point. Let's look at the partnership fund. Although we have established that a partnership is not a juristic person, does not have legal personality, and that the partners are liable for the debts of the partnership. I'm going to copy and paste this and just bring it forward, just so that you can remember. And that doesn't change. However, the law does recognize the establishment of what is called the partnership fund. That doesn't turn a partnership into an entity, doesn't turn it into a juristic person. But our law does recognize the establishment of the partnership fund, which is important for two reasons. For outsiders, creditors must first claim their debts from the partnership fund. So if the partnership owes a creditor money, the creditor must first claim that debt during the existence of the partnership. This is important here. During the existence of the partnership, this creditor must first claim their debt from the partnership fund. And only if the partnership fund has been depleted, if there's nothing left in the partnership fund, can they then proceed to claim their debt from the individual partners. This does not, as I've said, this does not make the partnership a juristic person. If there's no money in the partnership fund, the individual partners will remain liable. But outsiders must first discuss the partnership fund. Between partners, the existence of the partnership fund is not that relevant during the existence of the partnership, but upon dissolution, if the partnership is dissolved, whatever remains will be shared between the partners. So there, obviously, it is important for them during the existence of the partnership fund. It is important for creditors to know whether specific assets form part of the partnership fund or not, because it will determine whether they can attach them or not. Upon dissolution, once all the debts have been paid, if there's any funds remaining in the partnership fund, then those funds will, the partnership fund will be shared amongst the partners. Then it becomes important for the partners to establish this farm, this truck, this whatever. Is it part of the partnership fund? Can I share or not? I skipped over this, but you can look at this yourself. On page 74. Page 74 sets out which assets are normally considered in general rule, considered part of the partnership fund. The original contribution, property acquired with funds during the existence of the partnership, profits made, loans obtained, goodwill, etc., etc., etc. So now the question arises, I've explained to you there what is the relevance of the partnership fund? The question that now arises, what is in the partnership fund or not? Does a particular asset form part of the partnership fund or not? Now, this question is relevant to outsiders during the existence of the partnership. It's also relevant to the partners upon dissolution. And how we decide whether a particular asset forms part of the partnership fund or not will depend on, in fact, who is asking this question. With regard to outsiders, there must be formal transfer. So if Haiku has contributed his vehicle, but that vehicle remains registered in Haiku's name, Johnny Creditor will not be able to attach that vehicle. Similarly, Marilyn's farm, if it remained registered on Marilyn's name, Johnny Creditor cannot attach the farm for debts of the joint business, debts of the partnership. But between partners, it is different. Between partners, no formal transfer is required. But what is relevant is the intention. Form part of the partnership fund. So the intention of the parties, not the intention when it becomes to dissolution, because then obviously everybody is going to have a differing intention, whatever suits their pocket the most. But the intention at the time of entering into the partnership, did they intend this asset to form part of the partnership fund or not? No formal transfer is required. And now I'm going to take you back to what I said here. Because this is a repetition. This is not something new that I'm teaching you now. This is a repetition of what I taught you the last time when we had a lecture on partnerships. When was that? On Saturday. That partners have the choice to contribute the ownership of the property or just the use. But the default rule is that the ownership is contributed. If the ownership is contributed, it forms part of the partnership fund. If you don't want it to form part of the partnership fund, this must be expressly specified at the time of entering into the partnership. So I'm not teaching you new things. I told you on Saturday when we started with partnerships, there's a lot of repetition. So the concepts will become reinforced in your understanding. Exactly the same as what I told you here when we were speaking about contribution. Contribution also links to the partnership fund. Does this contribution form part of the partnership fund or not? Between partners, no formal transfer is required. The intention, whether it would form part of the partnership fund or not, is what um, is crucial here. And in the absence of a specific intention to the contrary, the default situation is that um, it will become. So this farm, even if it's still not, if it is still registered on Marilyn's name, it will become part of, there's no formal requirement necessary. It will become part of the partnership fund, which means upon dissolution, all the partners will have the right to share in this partnership fund. As you can understand, as you can see, use a little bit of common sense. This can have very far-reaching consequences. Always make sure when you enter into a partnership, not saying never enter into a partnership, it can be a very useful business form to conduct your business, but make sure that you have properly prepared and that or and that you don't end up suddenly at the end of the partnership losing your car or losing your farm. Questions about that? Okay, and then the last part of the work that I want to do today uh, deals with types of partnerships. In fact, there are many types of partnerships, but we look at only two types of partnerships, namely ordinary partnerships and extraordinary. Extraordinary partnerships. So ordinary, common or garden type, extraordinary, different from the ordinary. Now, in an ordinary partnership, that is what we have been studying, what we have been looking at since Saturday. All partners contribute. All partners are actively involved in the business. There's a joint business, and all partners share in the profits and the losses. That is an ordinary partnership. That's what we've been looking so far. That is how it works. An extraordinary partnership, so different from ordinary. All partners contribute, but one or more but not all. Do not deal with outsiders. Not saying they're not involved in the business. They can still be involved in the decision making, etc., etc. But they do not deal with outsiders. So they will not enter into a contract with a third party. They are not the face of the partnership. They do not deal with outsiders. And as a result of them not dealing about them being extraordinary partners, they don't deal with outsiders and they cannot be held liable. By third parties. Not saying they have no liability at all, but they cannot be, oh, this is important. I've got their shared profits and losses. Just so that you understand this, they still get to share in the profits. That's important. Otherwise, they wouldn't be partners. So they contribute, they share in the profits, but they're not actively involved in the business and they cannot be held liable by third parties. Not saying they are not liable at all. If my partners are Keelan, George, and Heiko, and Harana is the creditor, upon dissolution, I told you this on Saturday, I'm repeating myself. Upon dissolution of the partnership, joint and several liability arises, which means Rana can choose whether to claim her money from Keelan, from George, or from Heiko. If, however, Keelan was an extraordinary partner, she cannot be held liable by Rana. Rana can still hold George and Heiko liable, but not Keelan. George and Heiko, if they have paid, can still claim whatever they paid too much from her. So it's not a matter of no liabilities, but she cannot be called upon, like the other former partners, to pay the full amount. But in exchange for that, she does not have dealings with third parties. Now we get two types of extraordinary partnerships. The first is a silent partnership. Silent partnership works exactly like that. All the partners contribute, they share in the profits. Silent partner does not deal with outsiders, cannot be held liable by third parties. But the silent party can claim pro rata, as in, you know what that means? That is according to their agreement, relevant to their agreement. So the silent partnership can get their share, their pro rata share of the profit, and can be held liable for their pro rata share of the debt, as in if there are three partners and let's say they have agreed to be equal partners. Heiko is our silent partner. George has been called upon to pay, no, we had Keelan as our silent partner. Heiko was called upon to pay. Heiko paid the full 300,000. He can collect her share from Keelan, which is, if they were equal partners, a third of 300,000. So he can, if she has it, of course. If she's totally down and broke and she doesn't have it, well, Tough luck, Haiku, you can't get it back from somebody that doesn't have it. But otherwise, you can collect her share from Keelan and George's share from him. Rana, because she's a silent partner, Rana cannot hold Keelan liable. She can never claim the full 300,000 from Keelan because she was a silent partner. But if there was 300,000 profit, she gets her third, you get your third, George gets his third. Liability for debts, not liable to by outsiders, but liable for her pro rata share. Or alternatively, another type of extraordinary partnership that we have is a partnership en commandie. It's a French word, en commandie, or otherwise, if you prefer English, it is a commandatarian. So it's a double M, a commandatarian partnership. Now, how does a commandatarian partnership differ from a silent partnership? They are the same in the sense that all partners contribute, they've all contributed, and they do not deal with outsiders. So their silent partnerships and commandatarian partnerships are the same. Where they differ is that, oh, and sorry, also they cannot be held liable by third parties. Where the difference comes in is that their liability for the losses is limited to a pre-agreed. So whereas in a silent partnership, it was pro rata. So if it's 300, then it will be 100. Whereas in a commandatarian partnership, it's limited to an amount that they agreed upon when the partnership was established, which is usually the value of the contribution. It usually is. So the maximum amount of losses that they can be held liable for is limited to a certain amount. So it's not a pro rata share. So you might think, okay, but then this sounds like a much better idea. Let's rather do this. However, not liability, sorry, it's not liability for profit. Their right to profit share is similarly to a pre-agreed amount. Irrespective of the total profit. So silent partnership, if there was 300, if you've got three partners, they equal partners, profit is 300, they each get 100. If profit is 600, they each get 200. Commandatarian partnership, if things go wrong, they're protected against open-ended liability for the losses, but in exchange for that, their profit sharing is also limited. So they will only get their pre-agreed amount, and the rest will then be shared between the ordinary partners. Any questions about this?
This type of extraordinary and ordinary partnership, do they have a limited number of partners?
So there's never a limited number of partners, except that partners are generally, if it's not a professional partnership, partners are limited to 20. But that can, between that 20, it can be either they can be ordinary partners or extraordinary partners. There's no, except that there must always be at least one.
Okay.
There must always be at least one. There must always be at least one ordinary partner. So you can agree that one or this, I put it here, one or more, but not all of the partners do not deal with outsiders. In every partnership, there must always be at least one ordinary partner. So you can have 4 partners, of which 3 are silent partners, but there must still be one. You cannot all of you be silent partners. You cannot all of you be commandatarian partners. Can you think why? Why is that the case? There are 2 reasons.
Not really, no idea.
First of all, extraordinary partnerships do not deal with the public. They cannot enter into contracts with the public. Somebody needs to run the business. If they're all silent partners, who's going to be doing the contracting? So you need at least one ordinary partner to be contracting, to be the face of the partnership, to enter into contracts with third parties, because extraordinary partners are not allowed to do this. And secondly, extraordinary partners are not held liable for the debts of the partnership by third parties. There must be at least one person that the third parties can collect their debt from. So you can't, all of you, not run the business and all of you not be liable. There must be at least one person to run the business and to be held liable. Does that make sense? It's not a heavy legal concept. It's really just practical. Are you all with me? George is with me. Heiko, are you with me? Okay, it's nearly 2 o'clock. You need to get back to work. Thank you so much for spending your lunch break with me. It's just so much nicer having at least a few faces in front of me rather than sitting here just talking to my laptop. Yes, so thank you and enjoy the rest of your day. Bye.
Bye.
Thank you. Bye.